So thank you everyone for joining us, and people will continue joining, I'm sure. Let me welcome you to this CPD webinar on behalf of the School of Law of Euclid Cyprus and our strategic partners in this webinar. It is a real pleasure for me to welcome you all to this event tonight, this expert webinar, the purpose of which is to approach in a comparative perspective mediation in Cyprus and the UK, offering legal solutions towards the swift resolution of disputes to the benefit of all parties involved. And this is why we have experts with us tonight to talk to us about how to do that. So I would like to warmly thank the Larnaca Bar Association and the Famagusta Bar Association for their support in the organization of this webinar, including our guest speakers, so Mr. Christakis Mouscos, President of the Larnaca Bar Association, and Mr. Demetris Kallenos, Advocate, for their contributions tonight. Thank you very much to the two of you for being here tonight with us. As Christakis will actually convey to you, this is the first webinar in a series of CPD events organized by the School of Law of Euclid Cyprus to celebrate the signing of Memorandum of Understanding with the Larnaca Bar Association and the Famagusta Bar Association, respectively, in 2021, November 2021. So Christakis Mouscos will speak on behalf of both bar associations tonight. We are particularly happy to see so many legal practitioners of the Larnaca and Famagusta Bar Associations, but also beyond, to join us tonight, which is a tribute to the need for further professional development and legal education in the field of mediation. So we are particularly happy because mediation is close to our hearts here at the School of Law. I would also like to thank Ms. Emma McAndry, founder of Essential Mediation Solutions in the UK, with whom we have been working over the past years on mediation and educating mediators, offering to our undergraduate, but primarily our postgraduate students and externals, the possibility to train with us to become mediators in the context of our annual mediation month, which is held every year in February. So it is a great pleasure to have you with us, Emma. Despite your busy schedule, thank you very much for being with us. And finally, let me thank my colleague, Dr. Nevi Agapiou, for her constant support with all mediation-related courses and activities at the School of Law of Euclid Cyprus, and not only, as you will see tonight. Our main speakers' bios appear on the program of tonight's event, so I hope you will allow me to refer to the audience to the bios on the program rather than enumerate their extensive achievements tonight, so that we actually get to the real thing, which is to discuss mediation. Finally, I would like to thank all other colleagues who assisted in the preparation of tonight's event, as well as all of you who chose to attend this CPD webinar. Just to inform you very briefly, but maybe we can discuss it later again, that for those of you who are already registered mediators, we will run an 8-hour CPD top-up course on the 24th and 25th of June 2022 here at the Euclid Cyprus campus. So you're very welcome to join us. Before I give the floor to my esteemed colleagues and guests, let me just remind you of the rules of this MS Teams classroom. I will not enumerate everything because that would be a wasting time, but please do refer to the initial message posted in the chat by Nicolas, who actually advises you to keep cameras and mics off at all time, to use the chat function to talk to us. And I can see that many of you have understood how to do this. This is great to meet new people through the chat. And also, of course, to make sure that you take this webinar for what it is, which is an educational event and not legal advice or advice of any other sort by our speakers and participants. Also, make sure that all the lawyers who collect CPD points are with us for the whole duration of the event so that we can actually upload your participation to the Cyprus Bar Association platform after the event. So I will stop there, and I'm going now to give the floor for his welcoming to Christakis Mouscos on behalf of the Larnaca Bar Association and the Famagusta Bar Association. Thank you very much, Christakis.
Thank you, Stéphanie. Good evening and welcome everyone to the first seminar to take place after the signing of the Memorandums of Understanding between the Larnaca and Famagusta Bar Association and the University of Central Lancashire. The signing of the MOU codified a long-standing relationship between our associations and the university. Our common aim, of course, among others, is to marry the theoretical and the practical understanding of the legal system, and also provide an opportunity through the university to learn from specialized professionals from abroad. It is our hope that this will offer a more holistic education for those pursuing a degree, and also an opportunity for expansion to those already in the profession, bridging the gap between learning the law and applying it. And not only will the Larnaca and Famagusta Bar Associations and the University of Central Lancashire will be partnering in the education of their members and students, but we will also offer rewards, academic performance, seminars, sponsorships, and events where the legal professionals of tomorrow can meet the legal professionals of today. The legal landscape is always evolving, and especially recently, we had major changes to the functioning of the Cypriot court system, with modernizations such as iJustice, with the introduction of e-justice on the horizon, and the imminent legalization of the new rules for civil procedure. Along with the technological modernization of the legal system, there are changes to the expected duties also of the modern lawyers, stemming from constant revision of European directives such as GDPR or AML. These adaptations to the legal landscape only intensify the need for education and re-education. We hope to fulfill the role of supporting legal professionals and students to learn and evolve with that law in order to contribute to the competitive growth of the island's economy. I would like to thank UCLAN, our chair, Stéphanie Shaelou, our speakers, Emma McAndry, Demetris Kallenos, and Dr. Nevi Agapiou, who will begin today with unlocking civil and commercial mediation. Both Cypriot and British experts will frame the skill of a mediation in a plethora of contexts, spanning infringement, defamation, copyrights, and much more. The benefits of mediation are unquestionable. It is proven to reduce time, cost, and produce the faster outcome for clients. The aim of today is for those who attend to live with an understanding of mediation and its importance in serving a client's interest, along with a deeper understanding of its application and usefulness in combating the backlog of cases in the Cypriot court system. Furthermore, the aforementioned rules for civil procedure, when introduced, will be structured to promote the use of mediation as alternative to dispute resolution, and as such, it is imperative that legal professionals and also students that are familiar and able to effectively mediate. As such, ladies and gentlemen, I would like to express yet again my warmest welcome to both students and legal professionals, and we are truly looking forward to seeing our partnership flourish in the future. Thank you very much.
Thank you so much, Christakis. It's such a pleasure to hear from you how welcoming you are of the students, of the lawyers to be, of the mediators to be. This is very touching for us because we also believe it's extremely important. Thank you very much.
Thank you.
Emma, it is your turn now to tell us your views as to how to unlock the potential of mediation. And of course, you need no introduction. You are an expert of many, many years. We met you at UCLAN actually in the UK many years ago, and then you went on to become a practitioner, a very well known and reputed and prestigious practitioner. So thank you for being with us. We are listening to you. You have, according to my schedule, quite a long time to talk to us. You have until 6:50. Thank you very much.
Thank you so much for welcoming me there, Stephanie. And yeah, I'm very much delighted to be here, so thank you. And yes, it has been a number of years been supporting Cyprus. I'll just hopefully share my screen. Hopefully you can see the PowerPoint. I do have some time to talk to you, so I will try my best not to bore you. And there, let's see if we can, I hope you can see the slides there.
All good, Emma. You can start your slideshow. Perfect.
Thank you. Okay, so those of you who have been taught by me before in mediation will have heard this story before. So I apologise to those of you who have heard this story. Please do bear with me, but I just love it, and I think it really sums up the whole ethos of mediation. So we have an orange in a fruit bowl. You'll see there are two hands reaching into the bowl, and they are now fighting over the orange. What do you think you should do? Maybe you can shout out to me. What do you? Has anyone got any ideas? What do you do? Two children are fighting over an orange.
There's a comment in the chat from Nicola. Split the orange and share it.
Split the orange and share it. So maybe put it two. Yeah. Okay, that sounds sensible to me. Okay, so let's have a look at doing that then, shall we? Okay, so we're going to get a nice sharp knife. Here we go. Yeah, cut it in two and give a half to each child. Sounds sensible. This is what happens next. Okay, how do you think they look? Do they look happy? No. Okay, so we've done something wrong. We need to rewind and put a mediator's hat on. So what a mediator would do is say to the children, what's so important about the orange? What do you want it for? Tell me about its importance to you. And then the little boy says, well, I want to grate some of the rind into a recipe. And the little girl says, well, I want the flesh to make a fresh orange juice. So kids peel the orange, and then you've got happy children. If only every dispute were to be as simple as that. Clearly not. But I like that story because it just sums up the ethos of mediation, about how, you know, the conflict that we are at first presented with isn't as it seems. There's more going on underneath, and we try and make sure that parties come out of mediation mutually happy. Now, given we are having a mixed audience here, I just thought it might be worth briefly talking about what mediation is. I will keep this bit brief, but I just thought it might be worth just setting the scene for this. So mediation is a private process involving an independent individual who will help the parties to reach their own agreement. It is non-binding until the point of agreement, and the agreement will be binding if it's drafted properly as a contract. So the mediator acts as a facilitator and a conduit between the parties, helping them to communicate and negotiate. You may want to call it facilitated negotiation. Principles of mediation, as I mentioned before, it is confidential, so it is completely private, unlike at court when everyone knows what's going on, media, neighbours, friends, the public. It is common knowledge that you're in dispute. Mediation takes place behind closed doors. It is completely private and confidential. Another principle of mediation is that it is voluntary. You don't have to mediate unless you choose to do so. Unless, of course, it's a contractual clause between businesses that you have to mediate. The courts in the UK are strongly encouraging mediation, which I'm going to talk you through. And as you'll see, I have some doubt now whether mediation is truly voluntary in this country, and there is a move towards compulsory mediation, which again I'm going to talk you through. Another principle is that it is flexible. So the structure is flexible, the timing, you can mediate before you've issued a case in court or during the timeline of a case going through the litigation process. And another very important point is that it is the parties that decide the solution. It's their dispute and their solution. So the parties are ultimately in control of the process and have ownership of the outcomes. So the mediator doesn't impose a solution because they are not a judge, whereas in court, all power is handed over to the judge. Now, Christakis, in his introduction, mentioned some of the advantages of mediation. So I'll keep this brief again because of that. But what I've just said there is an advantage about the parties are in control of what they win, and they walk away having created a mutually satisfactory compromise. They may well come away mutually mildly unhappy, but the settlement is better for them than moving on to court with all the costs and time that entails. You can get much wider settlement options than you can at court. If you go to court, you just get money, whereas in mediation, it might be that you get an apology, you might be able to rework a business contract, you might have procedures put in place so this doesn't happen to anyone else, for example, in medical negligence. Another advantage is it is much more likely to preserve business relationships. So if you can imagine, if one business sues another and takes them through the court process, they're probably not going to want to do business with them again. Whereas if they say, why don't we try and mediate and sort this out amicably, they're much more likely to preserve their relationship. As Christakis said, it is much cheaper than going to court. There is a mediation fee, of course, but it is much cheaper than, as you can imagine, what lawyers' fees would be for the parties. It's much quicker. So there's a reference there to backlogs of courts. Yeah, mediation, if you ask me to organise mediation, I could probably fit one in next week. So it is much quicker to arrange. It's less stressful as well. The mediation process is supposed to be a supportive environment. So there is some stress involved, of course there is, but not as much as if you were going to court. And finally, there's a very high success rate. 70% of mediations settle on the day and another 20% shortly thereafter. So for the mathematicians amongst you, that's a total of about 90% success rate. I just wanted to give, before we talk about the UK, a brief history of mediation across cultures, just to put the UK into context. There seems to be sort of a tendency to see mediation as being a new trendy thing, but it's not new. It has existed in some guise throughout history and within a variety of cultures. Mediation can be traced back as far as ancient Greece and Roman times, and it was used in Aboriginal communities to benefit the local community. China and Asia have been using it for a very long time. Buddhism, Confucianism, they favoured communal accord and peace instead of the adversarial approach to resolving disputes. Additionally, in religion, that confirms the use of mediation throughout time. There is even a reference in the Bible to mediation. The Jewish faith as well has relied on the use of rabbis as mediators, being that third party in the resolution of disputes, as has Islamic law, which have also tried to promote peaceful ways of settling conflict. Bit of a timeline here for around the globe. So you can see there mediation in 1898 was implemented by the Congress of the United States for the first time as a formal legal practice to resolve disputes between organised labour and management. It then became really popular in the States between the 1920s and 1930s, and today it is a common method to solve disputes. It's very, very common in America to mediate. Canada, America's neighbour, they brought about mediation in the 1970s. Now, this was a response to concerns regarding backlogs, which is interesting. That's where we are today with COVID. Overburdened courts. So they brought about, in some states, a mandatory mediation programme. That was in 1999, and that remains today. I think it's in need of some overhaul, but it has stood the test of time. 1995, you've got Argentina enacting the mediation and conciliation law. That was as a result of the influence of the popularity of mediation in America. You've also got old roots in Nordic countries, as it goes back to the late 18th and 19th centuries. And then I just want to mention finally India, which is similar to China. The concept of mediation goes way back. There was a 2002 amendment of the Code of Civil Procedure Act 1999, and now mediation is one of the most common ways of looking. Again, there's a huge backlog of cases in the Indian judiciary, so it's to help with that. So you can see in all these different parts of the world, mediation in some form or another has been practiced, maybe informally, historically, but it's been turned into a more formal, legally accepted method of resolving disputes. So that's a journey around the world, but let's have a look at the UK. So despite the historical significance of mediation across cultures and religions, the UK's legal landscape didn't really feature mediation very much. We first started to see it in the UK when a body called ACAS began. Now, ACAS is a public body which aims to improve practices in the workplace. So they first started to form under a different name in 1896. The first commercial service in the UK was what we now know as the ADR Group, and that was in 1989, and that was followed by CEDA, the Centre for Effective Dispute Resolution, the following year in 1990. So compared with other countries and cultures, we've been quite slow really to get on the bandwagon of mediation. And what I'm going to do is talk us through now the emergence of mediation over the last 20 years or so, when it really became to the forefront in the legal landscape, and I'll bring us up to the present day. I think the first shift really started to happen in the legal landscape with Lord Woolf's review of the civil justice system, his Access to Justice Report 1996, and that resulted in the civil procedure rules as we now know them. So Lord Woolf recommended in his report that, as a minimum, lawyers should consider settlement by mediation, particularly because he said litigation should be used as a last resort. So that is included in the overriding objective of the CPR, and there are express references throughout the CPR for disputing parties to consider mediation at various stages along the litigation process. Not too long after the CPR came into effect, Lord Woolf gave judgment in the Court of Appeal. In the case you can see there, Cowles, and he criticised the parties for not using mediation. And he actually stated that this case will have served some purpose if it makes clear that the lawyers are under a heavy obligation to resort to litigation only if it is unavoidable. So that's referencing his words in his report about litigation being used as a last resort. Hurst and Leeming, again 2001, cost consequences were considered here for failing to mediate, and Mr. Justice Lightman said any unjustified failure to mediate would attract adverse cost consequences, particularly when there's a realistic prospect of settlement. They weren't applied, but they were considered. Then we have Dunnet and Railtrack, and here we did have a cost consequence imposed for the first time. So the winning defendant, the Court of Appeal, refused to award them the cost of their appeal because they didn't mediate. So Lord Justice Brooks said that he hoped that that judgment would bring the attention of lawyers to the possibility that if they don't mediate when suggested by the court, they may have to face uncomfortable cost consequences. So we've got a real upping of the strength of the court's thinking here. Now, Halsey and Milton Keynes 2004, that is a huge case in the mediation landscape. There's two questions here whether mediation could be made compulsory. So it's the first time the court has actually said, could mediation become compulsory? So the first question was legality. Is it legal to compel parties to mediate, bearing in mind Article 6 of the ECHR, the right to a fair trial? The court answered, no, it's not legal. Lord Dyson said that it would impose an unacceptable obstruction on the right of access to the court. They then looked at the desirability question. Is it desirable to compel mediation? And Lord Dyson again said no. He said that it's the court's role to encourage, not to compel mediation. So there's a resounding no to both those questions there. There was a thorough consideration of that, of those two questions, and it was a categoric no. But instead of drawing a line under whether mediation should be compulsory, it actually started a debate about whether it could become compulsory, and the decision attracted a lot of criticism. And we're going to look at what's happened to this as we go along. Another very important thing that Halsey decided was, although they can't compel parties to mediate, they did look at the issue of cost penalties for failure to mediate. Now, if you remember the cases I mentioned before, they looked at cost consequences, and did actually impose a cost consequence, but that was where it had been suggested by the court. The difference in this case is it was suggested by one of the parties. So this went to the Court of Appeal, and they held that where a party has unreasonably refused to mediate, it will be penalised in costs. Lord Justice Dyson identified a non-exhaustive list of reasons, which I've got on the slide there, which you could use as a reason for not mediating. I remember being in practice at the time and bulletins going around the firm saying, if you don't want to mediate, here's the excuses to get out of it. So that's why I've got my title Undermining the Shift, because although there is a shift to say that, yes, you can penalise parties for unreasonably refusing to mediate, here's a list of excuses to say no when you won't be punished. So there's clear encouragement, but there is some undermining there, perhaps. However, things have changed massively since Halsey, but I would maybe bear in mind that list and how that list there has been applied by the courts over time. And you'll see how it's been very much diluted. As you'll notice on these slides, there's a lot of cases. I don't propose to talk through all of them. They are there for your reference in case you want to go away and look at these afterwards. They are there for completeness. I'm just going to pull out maybe the main cases as we go along to talk about, given I'm conscious of time. So a much stronger approach has been taken since Halsey in applying those excuses or reasons. So in Birchall and Bullard, Halsey was applied, and the reason given for failing to mediate in this one was that they believed their case was watertight. Now, if you remember Halsey, they said that the merits of the case can be used as an excuse. But the court didn't uphold that here. They said, even if you think your case is watertight, that doesn't work. Another reason they gave for not mediating was that their case was too complex for mediation. If you remember Halsey list, nature of the case is one of the reasons. So the party tried to use that, and again, the court said, no, we're not going to take that. So Halsey was applied, but not really applied, if you see what I mean. They looked at the reasons compared to the list of the guidance from Halsey, but they didn't match them up. A quote from that case, which I really like, so I'll share with you. The judge said, the costs would have been a drop in the ocean compared with the fortune that has been spent on this litigation. So the proportionality of costs is a huge thing when you're looking at the benefits of mediation. And the case of Daniel, that didn't directly involve mediation, but Lord Justice Ward made comments that strongly supported the process. Again, proportionality of costs was looked at here. The costs were £50,000 compared to an agreed damages of £7,000. So Lord Justice Ward in that case said, we can and we do encourage mediation. The earlier, the better. It does have an extraordinary knack of producing compromise. The Jackson report is another big event, I think, on the mediation landscape. So this is the Jackson Review on Civil Litigation Costs presented in 2010. Here, Lord Justice Jackson was realistic. He said it's not a universal panacea, but what he did say is that there should be a culture change of education and encouragement. He recommended that there be greater use of mediation in order to control costs, and that there should be a serious campaign to raise awareness of the benefits. Now that's interesting, talking about education there. Lord Newberger, who is the Master of the Rolls as well, he actually said in his talk in the same year that mediation should really be embedded in a law student's education. So, you know, the fact that UCLan Cyprus are actually introducing mediation into the, you know, the students' eye and awareness, I suppose, as undergrads and postgraduates, they are embracing Jackson and Newberger by informing the lawyers to be of the benefits of mediation. So the Jackson report did have a really good influence on the court's attitude towards mediation. The judges started to embrace it even more and took an even stronger approach. I just want to read a quote from Rolf and De Guerin there. The judge said that it was a sad case about lost opportunities for mediation. It demonstrates how wasteful and destructive litigation can be. And he also referred to the results of mediation being quite beyond the power of lawyers and courts to achieve. So that's the wider settlement options that I was mentioning before. So really much more strong support there after the Jackson report. It's that Jackson, not the other Jackson, by the way. Okay, so a couple of these cases on here are neighbourhood disputes. So the top one, Oliver, and then Bradley near the bottom, they're both neighbourhood disputes, and the courts expressed that they were particularly suitable for mediation. They also didn't really like the court's resources being used up with neighbourhood disputes when, you know, they could be dealing with cases, you know, which are very, very, very serious, you know, loss of life and that sort of thing, rather than diverting the resources to petty neighbourhood disputes. So they said they're particularly suitable. Probably the most important case on that slide there is PGF. So the second case there that I've highlighted. Now that changed the landscape of cost penalties again. So in this case, severe cost punishment was delivered because there was a failure to respond to a request to mediate. So there wasn't reasons given, and the test wasn't were they reasonable or not, it was silence, absolute silence to a invitation to mediate, and that became the equivalent of unreasonably refusing to mediate. So lawyers can no longer ignore requests to mediate. They can't put their head in the sand and hope it goes away, because they will be punished. So again, this decision is narrowing the scope of Halsey about the reasonableness of not mediating. The top case there, so Thacker, this is an interesting case because both parties were criticised for not engaging in mediation. So what's different about this case is that it wasn't about a refusal to mediate. It was rather the fact that they did agree to mediate, but the defendant caused multiple delays in organising it. So in the end, the claimant lost faith, lost patience, and just called any mediation off. The judge said that if the mediation had taken place, it would probably have resulted in settlement. This went to appeal, and Lord Justice Jackson in the Court of Appeal, he actually, I'm just going to quote, he said, "I would be astonished if a skilled mediator failed to bring the parties to a sensible settlement." So this case sends out the message that where mediation is obviously appropriate, both parties need to get on with it. If one party frustrates the process by delaying for no good reason, that will merit a cost sanction. So again, we've got another extension of the court's power to penalise for not mediating. The Court of Appeal messages have been really clear so far, very clear, very consistent. If you don't mediate, you'll be punished. If it's suggested and you don't respond, or you don't have a reasonable excuse, you'll be punished in costs. Gore, however, went the other way. And I'm querying that maybe that's a road case, because after that we sort of got back on track again, but there has been some inconsistency of the approach of Halsey here. Now, in this case, Lord Justice Patton in the Court of Appeal, he said he had difficulty in accepting that if a party wants their rights determined by a court in preference to mediation, then how can that be said to be unreasonable conduct? particularly when it's here, those rights are vindicated. So it does seem to be hugely contradictory. That statement in itself is very contradictory. And it is confusing because the same year in Thacker, the court says something completely different. I think the only rationale I can think of for this case was it wasn't about a failure to respond or failure to engage or silence. This was where there was reasons given for refusal to mediate. The reasons were clearly stated and the judge had found them to be reasonable. So I think that is the difference in this case. It's unfortunate that Lord Justice Patton made that statement, but I think the reasoning behind it does stand. The other case on this slide, it's not strictly about mediation, but I think it really makes the point. So the Baby Guard case, you may have heard of this case. It was a very, very high profile case, reached the European Court of Human Rights. In case you're not familiar with it, this was a tragic case about the treatment of a baby that was born with a rare genetic condition. The parents were fighting for him to get experimental treatment in America, and they wouldn't agree to turning off his life support. So the hospital were forced to apply to the court for the life-sustaining treatment to be withdrawn, to be turned off. So, like I say, that reached the European Court of Human Rights. When it then returned to the UK High Court, it had been agreed by every court it had been in that the doctor's application should be granted as being in the baby's best interests. Public opinion was deeply divided. There was an absolute media circus here over that case. And there's public protests outside the courts and the hospitals. There's abuse, even death threats made against hospital staff. So I think people tend to forget the doctors in these cases. Of course, the parents are going through a horrendous time, but the doctors as well are suffering from their point of view as well. Now, it was very interesting that the judgment of this case said, so it's Justice Francis. Now, he said that negotiating over the life or death of a child seems impossible. Of course it does. He said few disputants would be in a greater state of turmoil and grief than these parents and those fighting similar causes. However, he clearly believed that mediation should be attempted in all cases such as this. He said, even if all that does is to achieve a greater understanding by the parties of each other's positions. So he wasn't saying he imagined that a mediation would settle this case, because he recognised it was hugely difficult. You know, how can you negotiate over the life or death of a baby? But he thought that it would be enlightening, and that the greater understanding of each party of where each other were coming from. So even if it doesn't achieve settlement, it'll lead to greater understanding by the parties of each other's views. I would just add to that sentiment, actually, in that the confidentiality surrounding mediation would have prevented the hysteria around that case. I mean, that hysteria must have only served to exacerbate the stress of those parents and the hospital doctors who were involved in the matter. Whereas if it was all held behind the private doors of a confidential mediation, that could and probably would have been avoided. Let's move on to 2020. You see a lot of cases there. So we've obviously got a lot of action going on here about mediation cases. I'm just going to pick out BXB and the case below it, DSN and Blackpool Football Club, because they've got similarities. Now, what we start to have in 2020 is a new trend where directions orders are being made, obliging parties to consider mediation at all times. Okay, so these are directions orders, which are orders made along the life of a case, where the court is telling the parties you need to think about mediation at all times. And there's also, as part of that directions order, an order that if or when you're a party who is refusing to mediate when it's been suggested by the other party, then you have to serve a witness statement explaining why. So basically giving a whole reason why you're not mediating, so to show that you're reasonably refusing, and that has to be done within 21 days. Okay, so there's this new trend to order consideration of mediation, a new trend to even have these witness statements giving reasons. Now, in the first case, BXB, when the mediation was refused, they failed to serve that witness statement. So that case isn't just a matter of refusing to mediate, but they breached an obligation imposed by the court to explain that refusal. So of course that conduct was inevitably judged to be unreasonable. In DSN, however, the defendants refused, but they did give a reason. They said that they believed they had a strong defence. Now, if you remember back to Laulhé, the merits of the case is a reason, isn't it? So they believe they've got a strong defence. So they've done the witness statement, they've obeyed the court order, the court directions order, and they've lodged a witness statement giving a reason which reflects one of the grounds of Laulhé. Now, Mr. Justice Griffiths in that case said no defence, however strong, by itself justifies a failure to engage. So that again is diluting Laulhé again and saying that merits argument just doesn't wash. We've heard that a few times now, haven't we? So it's funny enough, in this case, it turned out they didn't have a strong defence because they lost, but they also suffered cost penalties because they unreasonably refused to mediate. So the message was clear from those cases. If there's a directions order to consider mediation, you can't ignore it. And it's also becoming very clear that a belief in having a really strong case, whether it's a claim or defence, will not suffice as a justifiable reason. Just to continue 2020, moving away from case law, obviously in 2020 we're dealing here with COVID, aren't we? So obviously, as you know, the pandemic has created a huge court backlog, both in the ability of courts to deal with cases quickly, but also COVID in itself has created a whole raft of conflicting cases as well. So there's a couple of things here that I wanted to mention. The government here published guidance on responsible contractual behaviour in contracts impacted by COVID. And within that, it specifically states that the government would strongly encourage, the wording is, strongly encourage parties to seek to resolve any emerging contractual issues through mediation before these escalate into formal intractable disputes. So we've got very strong encouragement by the government that any contractual issues caused by COVID, mediate them please, instead of going to court. And then also to help with these, Lord Neuberger, who I mentioned before, was the previous president of the Supreme Court. He was on the Radio 4 in April, and he was appealing for parties to consider mediation instead of going to court and having an expensive and uncertain litigation. Lord Neuberger's talked about mediation previously. I mentioned him before about saying, you know, law students should really have mediation within their law training. That was in 2010. He also spoke in 2015, and he was very strong in his support for mediation there, saying how it was very, very attractive. And even talked about mediation providing some sort of access to justice if they can't get into the courts, because the courts prevent them from doing so due to expense, perhaps, legal aid being pulled back and so forth. So strong encouragement there outside of the courts as well. 2021, again, in these cases, there's not so many cases here, but I wonder if that's because we're getting the message that we should be mediating, and if we're directed to look at mediation, we're doing it now. And Gregor Fiskin, the second case there, Court of Appeal case, they actually said there that strong encouragement from the court to consider mediation merits careful consideration and is not to be ignored or rejected. So again, really strong encouragement there. Again in 2021, we've got Sir Geoffrey Voss. Now, Sir Geoffrey Voss is the Master of the Rolls here in England and the Chairman of the Civil Justice Council. So he made a speech in March last year, and in that he said that what he hoped to achieve was to make mediation an integral part of resolving disputes. He said he ADR, he wants to say the alternative out of ADR, because he wants mediation to be mainstream. He wants every dispute to be tackled at every stage with the view of bringing about its compromise. In May last year, we had the CEDA audit. Now, CEDA, they're a non-for-profit organisation. They conduct a statistical audit about every 2 years or every 3 years. Now, in that audit, they look at various things. But in that audit, they show that the mediation sector continued to show significant growth. It was actually 38% growth in mediations from 2018. Now, if you think about that, includes a year of COVID. So COVID hasn't slowed down mediation. It's actually continued to increase, which is quite impressive. They also estimated in the audit that this year there would have been a saving of 4.6 billion in the country by commercial mediation. And the statistics for settlements remained high at 93%. The CJC report on compulsory mediation, I'm going to pick that up in my next slide. I'm just conscious of time, but you can see there's been quite a lot of activity from the government here. You've got the Civil Justice Council making a report. You've got the Ministry of Justice calling for evidence, and that call for evidence was with the aim of collecting knowledge about mediation, with the view to, well, they said their ambition was to promote non-adversarial dispute resolution. So that brings us up to this year. There's already been a couple of cases this year supporting mediation, and there's also been a recommendation by the Civil Justice Council that small claims under £500 should be mediated. So that comes very quickly after the CJ report on compulsory mediation. So where does the future go from here in the UK? So if you remember back to Halsey's decision on the legality and desirability of making mediation, that was a resounding no. Well, that I think has now been completely overturned. It's been repeatedly criticised, but in 2010, Lord Dyson, who actually made the decision, said it is clear that compulsory mediation does not breach Article 6. So he's admitted that wasn't quite right. The CJC report in 2021 last year, that thoroughly also considered this question and also decided it would be lawful if it wasn't disproportionately onerous, and in many cases it would be desirable as well. They actually suggested that stronger sanctions be imposed for not mediating. So at the moment we've got the cost consequences, but they suggested stronger sanctions such as preventing a case from progressing through the courts, or even striking out a claim or a defence. I want to point out here it's they're talking about compulsion to mediate, not compulsion to settle, and there's obviously a difference. They also suggested that mediators should be sufficiently regulated. So here in the UK, mediators are not regulated. Well, it's not compulsory for us to be regulated, but we can choose to voluntarily submit to regulation. So I've joined the Civil Mediation Council that has certain regulations and standards, so I've submitted to voluntarily be regulated by them. And the CMC are open to compulsory regulation. I think the blocks of making mediation compulsory have well and truly now been cleared. If you think about the backlog we've got at the moment, and you can look at Canada and India, and they brought in compulsory mediation to help with backlog, maybe that's the silver lining of COVID, making that backlog happen here, which is forcing us to consider making it compulsory. I think compulsory regulation will come in the UK. The framework of the CMC is already there, so it can happen quickly. We've seen that small claims now need to be mediated. And what I think will happen is that threshold of £500 will gradually be increased as the kinks are ironed out and get higher and higher. I see that as being more like a pilot for more valuable claims. It may be that if we don't go as far as compulsory mediation, then we have an automatic referral to mediation and have an option to opt out. So you automatically, so it's not quite compulsory, but you're pushed into the path of mediation, but you can opt out. And that's what the Civil Mediation Council wants. At worst, I think we will at least have mediation information meetings, which will be compulsory, as we have in family at the moment, where they have to meet with the mediator and consider mediation for their case. So I imagine mediation will continue to grow in the UK and will continue to be ordered more and more, and maybe will become almost compulsory. So thank you for listening to me. If you fancy becoming a mediator yourself, obviously UCAM Cyprus have a wonderful internationally recognised qualification. And those of you who are mediators, please do come to our CPD event on the 24th and 25th of June. And I would hopefully love to see you there in person. Thank you.
Thank you so much, Emma, not only for setting out the scene and the history and, the rationale, the evolution of mediation in the UK, which is something that I think most people are not aware of. I'm sure that everybody has realized how much Emma is passionate about mediation, and that her passion is actually contagious. So that's very good for all of us. Emma has been the recipient of multiple international awards in mediation, and I think that this is very well deserved. Thank you so much. And also for setting out what you think about, future prospects of mediation in the UK, because this is very helpful for Cyprus colleagues.
Thank you.
Thank you, Emma. I'm sure there'll be questions in the Q&A. Now, let's go to the Cyprus experience now, and let's welcome our colleague and practitioner, Demetris Kallenos, who is an advocate, as I said before. He's also a partner at Christakis LLC. Demetris is a mediator, like many of us here. He's he's the representative of the Larnaca Bar Association at the Cyprus Bar Association, and he sits on the dispute resolution committee, actually. So this is extremely relevant. And I see that you're also an executive member of the Cyprus Arbitration Mediation Center. I'm particularly happy about this because a few years ago, Demetris, we used to deliver arbitration courses for the Cyprus Arbitration Mediation Center, yes, between 2015 and 2018. And it was a real pleasure to work with the center. So I'm happy to see it, regaining ground and visibility. This is great. Demetris, the floor is yours. You have until 7:20. Thank you very much.
Thank you for the introduction. Dear colleagues, student friends, and Christakis, Emma, and others, thank you for your such kind words up until now. It was really interesting to find out exactly how mediation works now in UK. I would like to say that even though in Europe the main challenge is to promote mediation so that the practice will become a regular method of dispute resolution instead of an alternative one, it seems that in Cyprus we are still behind this. Even though we have a relevant law since 2012, we are still at a very early stage. Cyprus has the following legislation related to the mediation. Cyprus introduced mediation with the Mediation on Civil Disputes Law on 2012, which entered into force on 16th of November of 2012, and it harmonized Cyprus law with the Mediation Directive of the European Union. Other than that, mediation also, in Cyprus we also have a law for the mediation in regarding family disputes, which is active since 2019, and in my opinion, this law, it's an extremely useful legal tool, which will really help courts and will bring substantial improvements in the relations between parents, husband, wife, children, and so on, especially in cases on these very sensitive family cases with a very special dispute. Other than that, we have the alternative dispute resolution for the commensurate law, which was introduced in 2017. The law ensures that the disputes arising from the sale of goods or the provision of services between consumers and traders can be submitted to an alternative dispute resolution body. And this was also in accordance with the European Directive of 2013. Finally, in Cyprus have established a unified body for out-of-court settlement of financial disputes since 2010 through the Financial Ombudsman of the Republic of Cyprus, who cooperates with certified mediators in order to resolve financial disputes between customer and banks or consumers. From the four national laws that I have just mentioned, in practice, actually, only the two of them are in force. So we are, by my experience up until now, the public only knows how to apply for consumer disputes, and in very rare cases, due to the fact that the banks have promoted that, public it's familiar with the financial disputes and the financial ombudsman. So having said that, I would like to say that in reality, we are still, even though we have the law since 2012 regarding the civil disputes, there is no real practice. And that's the reason that the Cyprus Ministry of Justice and the announced that they are planning to reform the law and the core of the mediation law in civil disputes. Unfortunately, in the Cyprus Bar Association, we received a draft of the proposed reforms, and I believe that it is fair to say that the changes will not be enough in order to actually promote mediation. It seems that the adoption of a mediation law alone, it will not help us as professionals, and it will not help the public to understand the real benefits of mediation. In my opinion, in order to succeed a spread of the mediation, we will need a cooperation between the ministry, between the courts, and the lawyers. Due to this, the Cyprus Bar Association and the Arbitration and Mediation Committee, which I am a member of, it is aimed to promote different acts in order to and take different kind of actions in order to succeed to the reform of the mediation. The action that need to be done has to need to be targeted on the following: immediate information of the public and the lawyers in order to increase the level of awareness of mediation as an alternative dispute resolution. The legislative will need somehow to promote compulsory mediation, and even in a pre-trial phase, in order for the lawyers to start promoting, to promote mediation to their clients. Also, the reform that it's under that they are planning to do needs to take the consideration the following matters. The results, they need somehow to to give enforceability to the agreements that they will result from the mediation and the procedure that we will follow, and they need to give clear instructions and an easy way for these agreements to be submitted at the court in order to get the legalization that they need. The results of the mediation in this way, the result of the mediation will really help, and it will become binding for all parties. Also, the qualification of the mediators needs to be clarified, and somehow a unified body needs to be established, like the Cyprus Arbitration and Mediation Center, who will deal with all these matters. Matters like conflict of interest and the fees that it's going to be applicable on every occasion needs to be specified, and this should be very transparent to the public and to the clients that they will decide to use, to the parties that they will decide to use mediation. Education, it's another thing that it's really important. We are in the committee of the Cyprus Bar Association. We are trying to to speak with all the parties that relevant parties like you, that they are offering education on regarding the mediation process, and trying to give we are trying to make this continuance in continuance. So we are suggesting that somehow we need to keep the education going on every year or every 2 years in order for to succeed a high level of professionals regarding mediation. The new rules of the civil procedure that they are planning to be announced very soon. It is absolutely necessary to be designed and reformed in a way that the court system and the institution of mediation can work together in a balanced without interfering one into the other. In my opinion, a specific set of rules regarding compulsory mediation should be introduced so that this obligation on behalf of the parties will not result in any additional delays or an increase of the cost of the procedure. Also, I would like to say that the existence of mediation by itself is definitely not enough in order to promote and change the use of mediation in practice. We need to work on the culture of the professionals, of the public, in order to make them see the full benefits of the mediation and how how this progress will save them time, money, because we all know, and I do agree, that the mediation is way cheaper, let's say, from the legal cost that someone will need to pay for 5-6 years until his case will be finalized at the court. So having said that, it seems that we have a lot of work to do in Cyprus in order to make the alternative dispute resolutions a reality. I have mentioned before the family law, that the mediation in the family for the family disputes, that it's been has been applied since 2019. It is with it is unbelievable, but unfortunately, it is a fact that we are still we have the law, but the law is inactive because we are still waiting for the rules of the procedures to be approved by the minister and the parliament, in order for us as professionals to be able to use this useful legal tool, as I said before. So it will be really helpful to promote seminars like this, with people like Emma, professionals like Emma, who can give us, can enlighten us on the way that the mediation has been established in other countries and the extremely good benefits that people are enjoying, the public have enjoying because of that. Another reason that mediation and arbitration needs to be promoted, and because we did not manage to do that, we are facing a huge problem. It's with the backlog of the in the court cases. Unfortunately, due to the fact that all disputes are ending to the courts, we are not able to help the court system and the judges to work effective and to solve the to have a result on different disputes or cases in a normal time frame, which is not 6 years in average, for if the case will not have an appeal, will not end with an appeal. Otherwise, the time will be estimated, the case will estimately end in 10 years. So the reality in Cyprus is that we have tried by setting the law and the tools, but unfortunately we did not. The government and the parliament did not give us up until now the right tools in order to use these laws that was in fact a harmonized they harmonized Cypriot law with the European Union laws and rules. As a conclusion, I will say that we need to we need to work and embrace arbitration and mediation until the time that the public will see the full benefits of this process, and will help us as professionals and anyone else who would like to apply for this procedure to have a fast and easiest and more a decision that it will be under their control. As Emma said, we are not mediation that only ends if both sides will come in an agreement. So that means that mediation have one main purpose: to keep both parties happy, like the children with the orange on the beginning. So we need to make this part of our culture, and we need to still keep working through this way. Don't know if there is anything to say. Unfortunately, mediation, I have been a mediator since 2000. I've been a mediator since 2013, and up until now, I was able to act as a mediator only in 2 cases, and I consider myself lucky one, since the majority of our colleagues, they did not had the chance to act as a mediator and put in action. They was not able to serve their clients and deliver the benefits of mediation through that process. I will close my my saying as a close statement. I would like to say that I believe that the new committee of the Cyprus Bar Association, the committee of the arbitration and the committee for the arbitration and mediation are working very closely with all sides in order to succeed and change the culture, as I said, and to give to the public and to the professionals the right tools. Also, in the Cyprus Arbitration Center, we are investing heavily in order to collect or to manage to join the different small centers that we do have now in Cyprus, because we are not the only one. We are just the only one who it's running by the Cyprus Bar Association without any interest. We are just using this center in order to promote the reform of the legislation and to make all the other centers cooperate in a way that it will be on the benefit of mediators and the mediation profession in Cyprus. I know that what I've said until now, it's not what someone would expect to hear from a professional, but I was very, to be honest, it troubles me if what I would say, or if I will present things in a happier way or an easiest way for a new professional who will who will become a mediator. But I believe that it's better for them to know that there are huge benefits from the mediation process. It can be work, and it can really help our clients and people that they will decide to choose mediation. But until we will come to this place, we still need to work all together in order to succeed the things that I have said before.
Thank you very much, Demetris. I think you have given an actually a very accurate and realistic picture of the landscape of mediation in Cyprus. I think you've been that has been extremely helpful, and that's probably why one of the reasons why it's important to also look beyond the frontiers of Cyprus into international mediation. So in other words, getting qualifications that are recognized internationally makes more sense. Given the difficulties in Cyprus, and given the time that we are looking, we are sort of anticipating this is going to take, but we are, willing to support as well the efforts of the Cyprus Bar Association in whatever way we can, not only through education and awareness raising, but even through, suggesting ways forward and so on, because we do believe that, as Nevi is going to present, unlocking mediation in Cyprus has a potential to basically facilitate other legal reforms, such as the ones you just mentioned. So thank you so much for being, for painting that legal landscape picture, because that's very helpful. Thank you.
Thank you.
Well, now let me welcome Nevi Agapiou, who is a lecturer here at the Law School of Euclid, Cyprus. Nevi is a lecturer in international commercial law and dispute resolution, and she specializes in international commercial mediation, but also international commercial arbitration. So she's the right person to pick up on what Demetris just said, and attempt to make good use of what Emma has presented, which is obviously extremely helpful, and show how we, the academics, even if we are mediators and arbitrators as well, we're able to feed into the discussion and try to suggest ways forward. So thank you, Nevi. We're listening to you.
So thank you, everyone, and a particular thanks to Emma and Demetris for indeed allowing me to build on what they've said, because I will be building on what both of them said. So for Demetri, I'll be making some very specific recommendations, suggestions. So I mean, feel free to take those forward. And you know, as academics and as a university, we are available to assist in efforts, because I do think there's a light at the end of the tunnel. So let me just share my PowerPoint slides, and I will start. So I actually do think that there is a way of unlocking the power of mediation in the Republic of Cyprus. So first I'll speak about our legal system, which allows us to do that, but also our ADR culture or lack of ADR culture, the need for legal reform, but actually the relevant legal reforms that will take us forward in relation to the 2012 law, but also the new civil procedure rules, and then make very, very specific suggestions. I have tried to keep myself to the time allocated, which is why I've been selective. Of course, I'll try to do my best to present everything in the time that I have. So we have a unique legal system that we should be celebrating at its core. So we belong to a small group of legal systems that were once part of the common law world, but we have moved somewhat away from that legal family since independence in 1960, also by virtue of our status as an EU member state. But we are still more of a common law jurisdiction than not. Now, the fact that we abide by common law, we follow common law, our legal system is infused with common law principles and methodology, means that we are flexible enough to embrace developments. We can take the law, but also the legal system forward. I would say it's relatively easy as long as there's a will. Now, I do agree with Demetris in that, you know, we do have a very poor ADR culture, which has contributed to our judicial backlog. So ADR is underdeveloped in Cyprus. Judges often ended up acting as de facto conciliators in an attempt to resolve disputes. As a result, valuable court time was and is wasted doing work that could be more appropriately be done by an ADR professional. Now, I was lucky to have empirical sort of research in my hands, which shows that there is a will from the lawyers. So the legal professionals are very much willing to embrace ADR and work with ADR to assist the legal system. So in the evaluation of the justice system in Cyprus, this was an empirical research project that was undertaken by the Civil Procedure Unit at the University of Nicosia. Great discoveries were made, confirming that, yes, there is fertile ground for us to move. So the sample was 228 practicing advocates, including advocates working for the Law Office of the Republic. Now, the numbers are excellent. So 82.5% believe an ADR culture can be developed if regulations encourage parties to move towards that direction. 71.5% consider that compulsory ADR processes should have existed, at least for some disputes, before the start of the court process. 79.4% believe that the wide use of mediation would be beneficial if the system encouraged the parties to move to that direction. And 86.4%, that's the highest sum, which is it's actually the most important. 86.4% of lawyers actually said that they would encourage their clients to use ADR processes instead of pursuing litigation if a satisfactory ADR system existed. So we really need to focus on fixing, correcting, establishing a good ADR system. Now, our operation of the judicial system, we all know that you know, it's a serious challenge. We've been trying for many years now to achieve greater efficiency of the judicial system. Operating under the hold of COVID has, I think, exacerbated the situation. The length of court proceedings was and is amongst the longest in the EU, and the level of backlogs in litigious civil and commercial cases is among the highest. So practicing advocates know that firsthand. So there are serious deficiencies as regards to the quality of the judicial system. We do have some new tools that are relatively recent that I do believe will be of great assistance in the future. So iJustice, for example, because it was picked up that we were lacking in the availability and use of information communication technologies. We have that, so that needs to be embraced. But the use of ADR methods was also picked up. Now, the new civil procedure rules approved by the Supreme Court actually do embed ADR methods. I would have liked to see more of that, but at least they're there and they have been incorporated in such a way that should harmoniously work. And then, of course, in relation to standards on timing for case management or other performance measures, which again has been tackled. So we just, I think at this point, need to be patient and embrace the new civil procedure rules as best as we can. Now, there is the alternative dispute resolution for consumer disputes law. I won't be really focusing on that. I mean, this is a relatively new law. It had actually, we had to sort of retranspose this directive into the national legal order because it wasn't done correctly the first time. But of course, there are challenges because not all sectors or claims are covered, and then traders are not interested to engage in ADR because it's not made compulsory. And because we lack an ADR culture, then they simply don't want to use it, okay? The fact that we lack an ADR culture also affects consumers who are not willing to pursue their claims against traders. So it's basically having, I mean, we have to work to awaken and really infuse the ADR culture in people. So it's not just legal professionals and judges, but also people, citizens. I will focus on the certain aspects of mediation and civil disputes law of 2012 that Demetris also mentioned. So just because this was the subject of the public consultation in late 2018, so it was enacted on the 16th of November 2012, so we are close to a 10-year run. It basically introduced a non-compulsory facilitative mediation model. So the parties choose a mediator from the register of mediators that the Ministry of Justice holds. The parties agree in consultation with the mediator the way of conducting the procedure, its duration, the obligation of confidentiality of the process, the remuneration of the mediator, and the terms of payment and any other matter deemed necessary. And of course, there's also provision for the enforceability of the compromise agreement by the court. Now, there was a public consultation by the Ministry of Justice and Public Order where a report was issued. I remember the report. It was about 10 pages at best, and it gave the main points that came as a result of a review by experts. But there was no transparency as to who had prepared the expert report. I was wondering why we didn't get to see the expert report itself, and we were seeing this sort of reduced document. Nonetheless, we did respond as a university to that, as a school, and reform is still pending. I would be very happy to see the bill that Demetris mentioned, but again, it's difficult with sort of transparency and how these are published, but that's another issue. So some of the proposals included in that small report spoke about mediation being made compulsory for all claims up to 10,000 euros for new and pending cases. Mediation referral was to be made right after the defendant files a notice of appearance to court. And in all remaining cases, a trained registrar to always inform parties about the possibility of mediation. And there was also mentioning about making mediation compulsory in two specialized courts, the Industrial Disputes Tribunal and the Rent Control Tribunal. There was a proposal in relation to financial sanctions imposed on parties refusing to engage in mediation, as well as financial motives, for example, returning court fees and the civil procedure rules. There was talk about appeals to be automatically referred to mediation, which is problematic. But what is not problematic is the idea or proposal to create a central mediation entity under the supervision of the Ministry of Justice and Public Order, who's sort of the umbrella body sheltering or taking care of mediation in Cyprus, responsible for quality assurance of mediation training and services, accreditation, and disciplinary matters. Now, the UK actually have the Civil Mediation Council, which has this role, and it's working really, really well. So I am applauding and supportive of this suggestion here. There was talk about removing the practicing lawyer requirement. Rather, a university degree would be needed, plus 3 years of professional experience for one to be registered as a mediator after training in one. That is also a very good proposal because, I mean, right now there are some restrictions. Opening up, the opportunity for someone to train as a mediator would mean a bigger catchment. So again, I would be in favor of that. And of course, there was talk of ADR methods to be included in the Cyprus bar exams, but not a lot of information was given. So there was no specific detailed proposal, really. So which was disappointing. But I mean, at least these were the main consultation proposals so that you get an idea. I don't know what made it or did not make it into the bill. I have not seen the bill. If I'm able to see that, that would be great. But I'll be making some suggestions that can be taken forward if we're now in the process of reviewing the bill. Now, it's an oxymoron, the fact that we speak of, the fact that we lack an ADR culture, but we actually have a high number of registered mediators in the Republic of Cyprus. I'm not looking at the family mediation, so I'm just focusing on civil and commercial mediation. So the register of mediators where the mediation in question concerns a commercial dispute numbers more than 400 mediators, whereas the register of mediators where the mediation in question concerns a civil dispute other than commercial, only listing advocates, numbers more than 200 mediators. This is a high number for the size of the country. I also do think that we are able to provide excellent ADR services as legal professionals. So we do have the trained mediators to take things forward. It's a matter of pushing the agenda of mediation and perhaps lobbying as well. Now, with compulsory mediation, I know Emma mentioned that it's, the UK is very close, has some elements of compulsory mediation, but there have been discussions for years. And for Cyprus, because we lack an ADR culture, in my view, I think mediation should not be made compulsory at this point. I do think that we must first try to develop an ADR culture in Cyprus by first strengthening mediation specifically, since we are talking about mediation, through a number of legal and regulatory reforms, education and specialized training, as well as promotional campaigns. So I'm actually very specific in terms of the ideas as to how we could do things, okay? Now, my advice to whoever is sort of looking at reforming the relevant law is to actually rely on what would be common law legal transplants versus civil continental law transplants. It seemed to me when I was reading the report back during the consultation process that there was a lot of civil law influence. Not necessarily, but I felt, it wasn't necessarily ignoring our common law identity. But if you look at comparative law literature, when you are attempting to effect a legal transplant, you have to check that the host legal system is actually capable of accepting it. And there's a lot of parameters that need to be checked. First and foremost, the users. We already have trained mediators, and in terms of education, I think legal professionals in Cyprus are either initially, because they then get the same training, they would have had a civil law background by either studying in Greece, let's say, or a common law background by studying in the UK, obtaining a British LLB. But nonetheless, then everything is streamlined through the Cyprus bar exams. But common law prevails, so it makes sense to look towards a common law jurisdiction. Look at the English experience, and this ties in now. I mean, back then, 2018, we did not have the approved civil procedure rules. Lord Dyson was very clear in that the inspiration for the new civil procedure rules actually were the English civil procedure rules. So it's just the sensible thing to do would be take what is working well with those civil procedure rules and try and see if you can transplant it into a smaller common law jurisdiction with its own peculiarities. So when you are involved or trying to effect a legal transplant, there needs to be some tailoring, some molding, some sort of safeguarding of features, and it's a process that needs to be done very, very carefully. So that's one thing. Look towards common law legal transplantation, which would be easier. It's the legal professionals would take to it faster, but then education and specialized training. So there needs to be a requirement for Cyprus universities to embed ADR methods into their undergraduate law degree programs, both theoretical and practical training. I know we do that at the university, but perhaps not every university does it. And I mean, we cannot have control of universities abroad, but at least for Cyprus, that is something that can be done. There needs to be practical ADR training, specifically negotiation skills in the exams, so the teaching leading up to the exams of the Cyprus Legal Council. Now, with ADR training, it would simply be, checking that there's an awareness and an understanding of what the different ADR methods are, but not necessarily giving trainee advocates mediation training, because that's very specific. It needs to stay as the 40 hours training that it is, because it's a journey, and every mediator needs to go through that journey. But negotiation skills is what needs to be embedded in the exams. According to Lord Justice May in Adr and Prime Meridian, mediation is a form of mutually assisted negotiation. So we have to ensure that advocates have mastered negotiation skills. And these negotiation skills will not only help them if they then want to become mediators, they will also help them negotiate cases, disputes on behalf of their clients, which is another ADR method. So negotiation on its own needs to come, I would say, before mediation. So when you have a dispute, I think there needs to be an inter-party discussion. It's organically that happens. But then when a lawyer is drafted in, the lawyer needs to be very careful in how fast they will get involved. They can stay in the background, guiding the parties without the word lawyer coming up, because of psychology when parties are locked in a dispute. But negotiation on itself is an ADR method, and then those skills could be used as a mediator, but generally as an advocate. So that will have many benefits, and there is a specific training. There's this specific module that can be created out of that. Also, mediation needs to be embedded in the country's educational system through curriculum development and related activities. So the teachers need to be trained. So train the teachers to then train the children. And I do think that children can start to appreciate basic principles of conflict resolution as young as 6 years old. There is even a module at that age where teaching those skills could be inserted. Again, we just need to create the opportunity by training the teachers to then train the children. And promotional campaigns. Now, this needs to be a highly specialized campaign, and we need to get everyone involved. For example, the Ministry of Justice and Public Order as the guardian of the institution of mediation today. but also the Cyprus Bar Association in collaboration with the Cyprus Association of Mediators, because we need to remember that mediation goes outside the defines of legal professionals. Psychologists can be mediators. You can have civil engineers, architects. So it needs to be a specific way, and it could be done through TV and social media via informative short videos, using simple, intelligible language that the lay person, the citizen, could understand, someone who does not have a legal background. Okay, now hopefully all of this will contribute to the development of an ADR culture, but I think we need to be patient and not rush, because the danger would be if you make mediation compulsory for civil and commercial disputes, at least. Making mediation compulsory in family disputes is a very different issue, because there you have lifelong relationships that need to be maintained no matter what. But for civil and commercial, we need to be very, very careful. Now, with reforming the legal and regulatory framework, so I've already mentioned that when we are looking at the 2012 law, we need to ensure that any legal transplantation is done correctly, but also that it is aligned with the new CPR rules that do touch on elements that have links with mediation or potential links. So I mean, I wish I had time to go into that, but I'm afraid I'm just giving you sort of the relevant parts. But also, this law needs to be strengthened to possibly include other forms of mediation, such as evaluative mediation. So right now we have the facilitative mediation, which is the true nature, the true form of mediation. But what we can do, and I do think that this will help the backlog as well, we can have what is known as evaluative mediation. So a mediation that starts as facilitative mediation, but the mediator will go further, provided that he's asked by both parties and actually evaluate the legal merits, giving an opinion on the likely outcome, which is why for evaluative mediation, you have legal professionals acting as mediators. And this may sort of alleviate a little bit of the sort of the opening up of the mediation registration possibility to other professionals. Another good step would be for the Republic of Cyprus to ratify the Singapore Convention, which entered into force on the 12th of September 2020 on questions of time. So this currently numbers 9 parties. Now, this is a uniform and efficient framework applicable to international settlement agreements resulting from mediation concluded by parties to resolve a commercial dispute. The goal is to facilitate international trade and commerce by enabling disputing parties to easily enforce and invoke settlement agreements across borders. So, I mean, it's relatively new. It has 24 signatory countries. It currently numbers 9, and the number will keep rising. How arbitration became what it is and gained its popularity, and I think its status, is through the support by legal instruments, international legal instruments. Now, this finally mediation got one such instrument, so I'm hopeful that it will do the same. But of course, Cyprus, I think, needs to get on that ship as early as possible. Finally, and I'll conclude, ADR clauses. So my advice to everyone, and it may be a very simple advice, for some, no, which you don't need to hear, but for others, I would say when you are drafting a contract, always ensure that there's an ADR clause in that contract. You have to explain to your client the significance and the value, the benefit, because an ADR clause will allow the contracting parties to agree that if a dispute arises, they will use an alternative form of dispute resolution, such as mediation, as a step prior to, or at least alongside, court action or binding arbitration. So it will save time. It has so many benefits, which I list there. It can preserve the relationship. It leaves parties in control. It's a simpler way of resolving a dispute. And this is how lawyers can actively promote the use of mediation. You can, if you routinely put in these ADR clauses, and you can sort of have them as multi-tier, negotiation, mediation, arbitration. Now, I quite like a MEDARB a MEDARB clause. Now, MEDARB is a hybrid, so this is a two-stage alternative dispute resolution process. So it usually involves the parties agreeing to grant a mediator power to convert automatically to an arbitrator. So usually the mediator is also an arbitrator, and they then, so that they don't lose time, they keep costs down, they actually they have the authority to make a legally binding arbitral award if the mediation fails. Okay, and then this will, the arbitration will be legally binding, and the arbitrator's award will be enforceable like an award rendered in standard arbitration proceedings, which is usually advantageous. So some, this very practical last advice on what you can individually do to promote mediation, but then of course some suggestions that need to be taken further to the Cyprus Bar Association, to the government, to the ministry for implementation. I think I'm slightly over, so I will stop here. Thank you.
Thank you, Nevi, for being, able to give some innovative ideas and suggestions that we've been working on across the years. And clearly, the fact that, you're both a mediator and arbitrator, but also an academic and a former practitioner, I think help the reflection. So thank you so much for sharing your thoughts with us. We have a bit more than 10 minutes for questions. So if I could ask Demetris and Emma to come back on screen, at least I can't see them. I don't know if others can. Here is Emma.
Yeah.
Thank you. And I would like to ask anyone who is currently participating to the webinar if they would like to ask questions. So the probably best way to do that is by writing a question or a comment in the chat, which I will be monitoring. In the meantime, Nicolas has kindly shared more information about feedback. We would love to have feedback from participants on the operation of the webinar, what you found useful, and so on, particularly because we're interested in finding out how many people are actually registered mediators and what are their needs, because we are talking about, a large group of people, as Demetris said, in Cyprus. A lot of people have actually trained in Cyprus, but not really been able to use it that much. So we are trying to, assess needs and see what we can do about that. So thank you for filling in the feedback form. Now, I don't see any questions for the moment, and I've got plenty of questions, but I see that Christakis has been listening very carefully all throughout. So I'm wondering if Christakis would like to say a few things, if you have any comments on what you heard, if you find it useful, and if you want to share something with us.
Correct, Stéphanie. I was listening very careful because, as I said at my welcoming speech, I think this is a very important thing. And with what Demetris and Nevi said, is something that we need to evolve. I would kindly ask Nevi to send me an email with everything, and I will try to, that she mentioned, and I will try through the Cyprus Bar Association to put in place and see. And as we were discussing before signing the memorandum, actually this was the purpose of our seminars. We had a practitioner giving the realistic picture of what's going on. We had Emma giving her experience from the UK, and we also had Nevi giving us exactly showing us where we must go in order to be able to fulfill. So I think this webinar was extremely useful, especially on that aspect. I hope that with the new civil procedure rules that we're going to see a lot more mediation. And my only question is to Nevi, on what she's thinking to be the right thing to do with the promotion. I mean, more to tell us in more detail how these promotions should be done, and also what changes she thinks it has to be implemented immediately in order to be able to unblock the mediation.
I mean, I would love to see the bill. I haven't had access to that. So if I can see the proposed bill, then I can perhaps give more tangible suggestions drawing in from my sort of wider recommendations. But so if you're referring to the promotional campaign that the Cyprus Bar Association, but also the local bar associations, I mean, you could also have, I think, more targeted sort of campaigns. Now, what works, and again, we have to appreciate our culture in Cyprus. So we now have universities with academics like myself, so not just UCLan, but there are other universities interested in promoting mediation, promoting ADR. So academics can be used with the support of the universities, can be used to bridge, because I mean, we also teach. So we have the know-how of how to sort of assist in the teaching without taking away quality in terms of understanding and ability to follow. What is needed for a citizen who may very well then be a party, and it's a client that you may be faced with, appreciate the nuances, but also the difference between the different types, because there are so many. So I think you could use academics, and I would be willing to assist. We also have, which I wanted to mention, so the research center of the School of Law, I claim, is actually an ADR entity for consumer disputes under the 2017 law. And through practical, experience and exposure, we have seen that, we lack generally an ADR culture. So even when consumers have made a loss, they're unwilling to engage in what may be, mediation or arbitration. Okay. So the small videos could be an academic, such as myself, could be less than, 3 minutes, explaining the differences. But above all, why should you be open to this? And by having an academic who is not, for example, we are affiliated with universities in Cyprus. Yes, some academics are also lawyers, but generally using universities that have the benefit they would have is that we offer back in society. We have impact, which is what interests us as a university, that we positively impact society. So by using the neutral sort of expert, you're able to then feed the correct information at the appropriate level for change to start to happen. And I'm really, I feel strongly about getting this into schools, because if you teach children that when they're fighting in the schoolyard, that there is a way, and if I cannot, because I'm feeling really upset, I'll go to my friend who I know is, calmer than me, and try and help us. So you have a team of 3, and if they grow up like that, when they then are faced with a dispute, they will be more open. So I think we do need, if we can have, the lobbying abilities of lawyers collectively to present ideas to sort of government bodies, ministries, people that can implement it, we can make change. And countries have piloted such systems. I think in the UK, there are, at least I remember in the 2017 conference, there was talk about this, in that it was the way forward. And then during my training, so I was trained at Cedar in London, and I met an Austrian lawyer who is working on exactly this, getting a manual for teaching mediation at children of a young age. Okay. So there's many ideas which I can put, but I would love to see that bill. very interested to see that bill. So if I can get access to it, that would be great. And I'll put everything in writing in a more in the form of a memo, which you can take forward. And of course, we would be happy to support. The university, the school has for years now been sort of building expertise and capacity. So it's not just myself and our head of school, other colleagues such as Dr. Maria Tatsu, Dr. Katerina Kalaitzaki, and our partners from the UK, Emma, but also Dawn. So we are building capacity to be able to properly promote this, not through training. There's other ways as well, through expertise and know-how. So
And also, Emma, if you can also tell us from your experience on because you were also discussing about mandatory, if it's going to be mandatory or it's not. I know that they use a lot of the expenses and the costs in order to push people to use mediation. So from your experience in the UK, it would be better to hear from you in more detail. How did you succeed to go from to use mediation in a lot more?
Okay, so I think it's a two-pronged attack, really. I think we've been lucky that we've had Lord Jackson and Lord Neuberger. We've had very senior judges shouting out, saying, you need to mediate. It's a much better way forward. So I think you need to find someone who's very sort of well known, very superior, who's got authority to shout out about it. There's been lots of speeches over the last 20 years, governmental reports and speeches where they've been really actively promoting mediation. So I think that's one thing. Another thing is, I just want to pick on what Nevi said about education in schools. I think that's massive. We do call that in England peer mediation, where school children will mediate. Schoolyard fights, as Nevi said, in schools. It's not massively common, but it does happen. And it's interesting because when I was at UCLan Preston, I devised a programme called LLB with mediation. Okay, now that ran for a few years, but it got dropped. The reason was 18-year-olds didn't really know what mediation was, and so it didn't recruit. So although it was successful for the undergraduates, they would jump onto it when they found out about it. It didn't recruit from 18-year-olds. There was a lack of awareness. So I think Nevi's completely right when she says it needs to start in schools. So there's your two-pronged attack. You've got one coming from the senior level of senior judges, government lobbying them, and then underneath coming from the school children and meeting somewhere in the middle. In terms of the compulsory mediation, there's a concern that it will sort of dilute the effectiveness of mediation because it's supposed to be voluntary, and there's the concern that it will become a tick box exercise. Okay, however, what I would say to that, I like to argue about anything that's anti-mediation. So what I would say to that is that many a mediation has happened as a tick box exercise or started off that way, but mediators have managed to persuade parties to compromise. I did one myself very recently. It was a neighbourhood dispute, and it's the guidance to the council so that you have to mediate or negotiate before you can put a complaint into the council. It was about hedge height. And so one party started the process because they knew that they had to do that. And during the mediation, it became very apparent to everyone they had no intention of settling. They just wanted to tick the box. However, after about 2.5 hours, we managed to settle. Okay. So, it's the skills of a mediator, reality testing and so forth, but we settled that one, and it was definitely a tick box. So I would argue against that, and if you look at the settlement rate of mediation being over 90%, where's the argument? But I completely agree, Demetris and Nevi, what you were saying about culture change. Where does culture change come from? It comes from education and awareness. Yeah, so schools, universities, promotions on TV. We need to get it out there. I mean, everyone knows about the law. There's loads of films, TV programs, books all around the legal system, and the juicy cases. But mediation has lots of juicy cases as well. So it's about informing everybody. That's what I think anyway.
Thank you for sharing your passion once more, Emma. I think that, you know, this is very welcome. And then that makes Demetris and Christakis react. This is very good. Demetris.
I would agree with both. I mean, and Evie and Emma. Even though Nevi said that it is not the time yet to proceed with a compulsory mediation. In my opinion, we can somehow use it as a pre-trial, just that the lawyers need to inform their clients that you do have this option, even though it's not necessary, you don't need to proceed with it, just to present a statement at the court in the beginning of the proceedings that we have informed our client. This is a step to promote mediation or into all the ages. I mean, to people that they are not in school, they are not in university, and how are we going to do that? Another way that we need to promote mediation, it's not, and I do agree, it's not only for lawyers, so I don't think that we want to have the exclusivity. It's for example, for the government to use mediation. For example, municipalities could use mediation for different kinds of claims that they have or disputes that they have. Government authorities, no one is using mediation. So we need to start from somewhere. In my opinion, yes, we need to educate our children. We need to give to the mediators that they will the best credentials that they may have, the best possible I don't know, guidance and so on. But also, if we are okay, my experience as a genuine Cypriot is that we are let's say we need someone to push us or to tell us that this is the correct way to be done. There is no one that could say that mediation it's not better than a court trial, at least at the beginning. As Emma said, they have 90% of succeed rates. So there is no other way to explain that. You can show the facts. But Nevi, with all the respect, I believe that a compulsory mediation, even in a pre-trial stage, just that they need to inform the client, it's really important.
Yeah,
that's my opinion.
Yeah, but they need to be doing that. Sorry, Emma. Another point that, I mean, I'm getting started now on the training of lawyers. I do think, I mean, I gave a speech, it was at the Civil Procedure Symposium at UNIC about the training of lawyers. So in terms of the professional conduct, when you, for example, when you're being trained as a barrister or as a solicitor in the UK, you know that that's the first thing you say to a client. And if you tiptoe around it or you don't say anything, you can get into trouble because there may be professional negligence. But there's no such thing in Cyprus. So
exactly.
You say that, I do agree. Every lawyer needs to be doing that. But unless we beef up the professional conduct and perhaps put it in the law that the lawyer has an obligation, then I don't see how it could move, which is why, you know, with ADR clauses, again, there needs to be sort of an obligation somewhere that you have to do that because it's to the best interests of the party. So I think there's other things that we need to fix. And we spoke of children, but let's say when we do take that trainee that comes straight from university, what do you do with them? Because not every university embeds legal skills into their LLBs or their bachelors. I mean, we do, for example, at UCLan, but studying at the University of Leicester for my undergraduate, there was no skills training. And unless I had then progressed with my own training that I pursued, I would not have had that from the Cyprus bar sort of experience. So I think there's other things that we can do to bulletproof the profession. So this goes outside, I think, the parameters of mediation. The profession, through proper training, and I think through strengthening of our Cyprus bar sort of the training, we can do a lot of good for I think for mediation, but for the system, for lawyers generally. So sorry if I just jumped in because it's the Cyprus bar exams is I have a, you know, if I'm passionate for mediation.
No.
Yeah, those are, yeah, they need to be improved.
Thank you very much. Yes, Emma, and then we have to conclude because we are 7 minutes late.
Yeah.
Yes.
So sorry, I'll just throw in a compromise potentially. Maybe think about, because Demetris, you're talking about compulsion, maybe start compulsion in the small claims and then grow it from there. Pilot it first.
Yeah.
Just an idea. I should talk now.
Very practical.
We will work on it.
It's
Very practical idea. Well, just to wrap up, I mean, obviously the discussion is very interesting. We can organize another, you know, follow-up discussion, CPD type discussion, or we can pick up in the 8-hour top-up as well, because this is what it is about. You know, what do we do with everyone who is a mediator? How can we use it in our everyday life? But I wanted to come back to what Demetris was saying and just conclude by saying, well, we were lucky enough to actually develop another project on mediation, but this time not addressed to lawyers. It's called social mediation. The art of doing mediation outside of the legal profession. So you mentioned municipalities. It works with communities, groups, and so on. We were lucky enough to be able to start it in Cyprus. We are now growing it global. We are spreading the social mediation practice to India, Africa. We've got members. We have a network of social mediators, members from different countries and 3 continents. And we were very lucky to actually receive the prize of the European citizen from the European Parliament for this social mediation project in tiny Cyprus. So you see, there is hope that we could embed mediation into our way of life, basically. And happy to discuss with Christakis and Demetris what this is about, and introduce you to another group of colleagues who are the social mediators, not the commercial mediators. Yes. So thank you very much, everyone, for staying with us and for listening and for being very patient, and to our speakers for being extremely engaging and I think extremely helpful in the discussion. We thank you very much. Christakis, I think, you know, for a first time, it's a good first time. I'm happy.
Indeed, I'm very happy, and I will be even more happy if Nevi and Demetris will continue from here and exchange information and the new bill, and for Nevi to give us more suggestions, and or even Emma from your experience, in order to be able to fix things through the CBA as much as we can. It was indeed a very fruitful seminar, and I do hope that we will have even better results in the future through our cooperation.
Thank you so much, everyone. Time to log off and go to our respective families. Emma, thank you so much for joining us from the UK. Thank you, everyone, for attending, and see you soon. And everybody take care. Thank you. Bye.
Bye.
Bye. Bye.